Before we begin, a quick and important disclaimer. The information presented in this video is strictly for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Divorce and the division of retirement assets, such as 401k plans, involve highly complex federal and state laws that are subject to change and vary significantly depending on your specific jurisdiction. We are exploring historical trends and case studies, not providing personalized counsel. Always consult with a licensed attorney, a certified financial planner, or a qualified tax professional before making any decisions regarding your assets, marriage, or legal standing. You must conduct your own due diligence, as relying solely on educational content for legal strategies can result in severe financial consequences. Imagine spending 40 uninterrupted years waking up before dawn, commuting through the bitter, unforgiving winters of Massachusetts, and pouring every spare dollar you earned into a retirement account, operating under the absolute belief that your financial future was impenetrable. You watched the balance grow through market crashes and economic booms, treating that 401k as a sacred, untouchable vault. Now imagine sitting in a sterile, wood-paneled courtroom in Suffolk County, listening to a judge effectively sever that life savings in half with a single strike of a gavel, handing millions of dollars over to an ex-spouse who never contributed a single cent to that specific account. This is not a dystopian fiction or a rare legal anomaly. It is the cold, hard reality of equitable distribution, and it happens every single day across the United States. But to truly understand how your personal retirement fund became a prime target in family court, we have to look at the birthplace of American wealth and property law, New England. There is a staggering and often misunderstood history buried in the archives of New England courthouses. For centuries, this region dictated how fortunes were built, protected, and ultimately dismantled. From the whaling fortunes of Nantucket and the textile monopolies of Lowell to the modern pharmaceutical and tech booms of Boston, the way money is divided when a marriage collapses has undergone a radical, shocking evolution. You might think your 401k, a financial vehicle that did not even exist until the Revenue Act of 1978, is shielded by federal law. You might assume the name on the account dictates ownership. You are entirely wrong. The moment you enter into a legal marriage, you unwittingly enter into one of the most binding financial contracts on earth, governed by a maze of state precedents that trace their roots back to English common law and colonial decrees. We are going to expose a system that has quietly transferred billions of dollars of retirement wealth over the last 4 decades. We will dissect the exact legal mechanisms that courts use to slice through federal tax codes, and we will reveal the devastating historical blind spots that catch thousands of individuals completely off guard every year. If you have a 401k, or if you plan to ever build substantial wealth, the hidden history of divorce in New England contains urgent warnings that you cannot afford to ignore. The story of dividing wealth in New England is fundamentally the story of American property law. Historically, under the rigid doctrines of English common law that governed early colonies like Massachusetts and Connecticut, a woman's legal identity was entirely subsumed by her husband upon marriage under the concept of coverture. Whatever she brought into the marriage, and whatever was acquired during it, belonged exclusively to the husband. Fast forward through centuries of grueling legal battles, and the Married Women's Property Acts of the mid-19th century began to dismantle this archaic system, allowing married women to own property in their own right. However, the true earthquake in family law did not strike until the late 20th century, perfectly coinciding with a massive shift in how Americans saved for the future. Prior to the 1980s, the concept of retirement was largely defined by defined benefit pension plans. You worked for a company for 30 years, and they paid you a set monthly amount until you died. When divorces occurred, these future pension payouts were notoriously difficult to value and divide. Courts across New England struggled with the abstract nature of a future promise of money. Was it actual property, or was it merely an expectancy that might never materialize if the worker died prematurely? The judicial landscape was heavily fragmented, with some judges ignoring pensions entirely, a practice that frequently left dependent spouses completely destitute in their later years. Then came the financial revolution. Section 401k of the Internal Revenue Code went into effect on January 1, 1980, originally intended as a minor tax loophole for executive compensation. Within a decade, it had entirely cannibalized the traditional American pension system. Suddenly, retirement wealth was no longer an abstract promise from a massive corporation. It was a highly visible, rapidly fluctuating pile of mutual funds, sitting in an individual account with a specific daily balance. This visibility changed the calculus of divorce practically overnight. State courts in states like Rhode Island, Vermont, and New Hampshire finally had a tangible, quantifiable asset to target during property division. But there was a massive legal collision waiting to happen. The 401k was, and remains, governed by strict federal law under the Employee Retirement Income Security Act, widely known as ERISA. ERISA contained a powerful anti-alienation clause, meaning that the money in a 401k could not be seized by creditors, and technically, could not be legally assigned to anyone other than the named account holder. State divorce courts were issuing binding orders to divide these accounts, and federal plan administrators were flatly refusing to comply, citing federal supremacy. This bureaucratic gridlock trapped thousands of divorcing couples in a financial nightmare. A judge would order a 50-50 split of a 401k, but the financial institution holding the money would refuse to move it, leaving former spouses locked in perpetual litigation, while their assets remained frozen. Congress was eventually forced to intervene, passing the Retirement Equity Act of 1984. This monumental act created a legal skeleton key called the Qualified Domestic Relations Order, or QDRO. The QDRO is an incredibly precise, highly technical legal document that essentially forces a federal retirement plan to recognize and execute a state domestic relations order. It is the crucial bridge between the family court judge sitting in Maine and the massive financial institutions operating on Wall Street. But establishing the QDRO was only the beginning of the complications. New England courts, particularly the Massachusetts Supreme Judicial Court, began developing complex precedents regarding how to treat these accounts. They established the philosophy of the marital enterprise, viewing a marriage as an economic partnership. Therefore, any funds contributed to a 401k during the marriage, and the passive market growth on those funds, are considered joint property, regardless of whose paycheck funded the account. This leads to incredibly complex financial forensics. What happens to the money you had in the account before you got married? How do you separate the active contributions made during the marriage from the passive market appreciation of the premarital funds? Courts had to develop sophisticated coverture fractions to determine exactly which dollars belong to the marital estate and which dollars belong solely to the individual. The timing of valuation became a battlefield. If the stock market crashes between the date of separation and the date the divorce is finalized, who absorbs that loss? In New England history, we have seen case studies where a delay in drafting a QDRO during a market downturn wiped out hundreds of thousands of dollars of intended settlement value. In this comprehensive video series, we are going to demystify this entire intricate system. We will explore the historical shifts in New England that paved the way for modern equitable distribution, examining how states with long-standing traditions of inherited, old money wealth adapted to the era of widespread individual stock market participation. You will learn the mechanical differences between how a judge in Massachusetts views a 401k compared to a judge in a community property state. We will break down the precise mechanics of the Qualified Domestic Relations Order, not as a dry legal textbook, but through real historical examples of what happens when these powerful orders are drafted incorrectly by inexperienced attorneys. We will look at potential outcomes of premarital contributions versus passive market growth during a marriage. We will dissect case studies where hidden tax liabilities completely destroyed the value of a settlement, leaving one party with an enormous tax burden because they failed to understand the critical difference between pre-tax retirement assets and post-tax liquid cash. By understanding the historical context and the sheer mechanical complexity of dividing a 401k, you will be equipped to understand the high-stakes reality of asset protection. This is about understanding the foundational rules of a legal framework that most people do not even realize they are trapped within until the gavel falls. To understand how this trap is sprung, we have to shatter the biggest myth surrounding divorce in the Northeast, the myth of the 50-50 split. If you live in California or Texas, you operate under community property laws, a system derived from Spanish civil law where assets acquired during a marriage are generally cleaved neatly down the middle. But New England history traces its legal DNA back to English common law, which birthed the doctrine of equitable distribution. Equitable does not mean equal. Equitable means fair. And in a courtroom in Massachusetts or Connecticut, fairness is a highly subjective, malleable concept determined by a single judge wielding immense discretionary power over your financial survival. Imagine a scenario playing out right now in 2026. Let us look at a man named Michael. Michael is a 45-year-old engineer working in the Route 128 tech corridor outside of Boston. He started his 401k back in 2010, years before he even met his wife Jessica. Over the last 16 years, through aggressive saving and compounding interest, that account has ballooned to $1.2 million. When Michael and Jessica file for divorce, Michael naturally assumes that the money he saved before the wedding day is safe. He assumes the court will only look at the contributions made during their 8-year marriage. This is precisely where historical precedent turns his reality upside down. Under New England legal frameworks, specifically the sweeping precedents established in the late 20th century, the burden of proof is entirely on Michael to trace every single dollar back to its origin. This is not a simple matter of looking at a statement from his wedding day. When a 401k is commingled, meaning premarital funds and marital funds are mixed in the same investment vehicle, the passive growth of the premarital funds becomes a massive point of contention in family court. Courts have historically debated whether the explosive growth of a tech-heavy 401k portfolio is a result of active management, which might be considered a marital effort, or purely passive market forces. If Michael cannot produce pristine, uninterrupted financial records stretching back over a decade and a half to prove mathematically what percentage of the current $1.2 million is purely passive growth from his bachelor days, a judge has the authority to dump the entire account into the marital pot for distribution. This forensic nightmare is a direct result of how courts struggled to adapt to the explosion of defined contribution plans. In the 1970s, judges dealt with pensions which were rigid formulas. They used a mathematical formula known as the coverture fraction to determine the marital portion of a pension, based on months of marriage divided by months of employment. But as historical trends shifted wealth from pensions to 401ks in the 1990s, courts improperly tried to apply this same rigid fraction to volatile stock market accounts. It was a disaster. Applying a time-based fraction to an account that grows exponentially through compound interest severely shortchanges the original account holder. Today, forensic accountants must reconstruct the exact historical market performance of the specific mutual funds held in Michael's account on a month-by-month basis to separate the marital estate from his separate property. When evaluating equitable distribution, a judge looks at a massive checklist of statutory factors. They look at the length of the marriage, the age and health of both parties, their respective earning capacities, and their future needs. If Jessica sacrificed her career to raise their children, severely limiting her own ability to accumulate retirement wealth by 2026, the court is legally permitted to award her significantly more than 50% of the marital portion of Michael's 401k to balance the scales. They use his accumulated wealth as a counterweight to her lost earning potential. But the true volatility of equitable distribution in a 401k divorce lies in the mechanics of time. When does the marriage actually end financially? Is it the day someone moves out? Is it the day the divorce complaint is filed? Or is it the day the final judgment is entered? In Massachusetts, the marital estate is typically valued at the date of the divorce trial. Now, consider the massive stock market fluctuations we have witnessed in recent history. Imagine Michael and Jessica agree in principle to a settlement in January of 2026, but their court date is not until October. If Michael's 401k is heavily invested in volatile tech stocks, and the market drops by 20% during those 9 months, the overall value of the marital estate plummets. However, if their preliminary agreement stated Jessica was to receive a fixed dollar amount, say $500,000, rather than a percentage of the total account, Michael is suddenly forced to liquidate a massive portion of his decimated portfolio at a severe loss just to pay her out. He absorbs the entirety of the market crash, while her payout remains perfectly insulated. This specific scenario has played out thousands of times across New England courthouses. Historical trends show that during major economic downturns, the rigid application of fixed-dollar settlements in 401k divisions led to catastrophic outcomes for the account holders. Courts eventually began recognizing the danger of market volatility, leading savvy legal practitioners to mandate percentage-based divisions. Yet, even in 2026, litigants representing themselves consistently fall into this trap. They agree to flat sums, completely ignoring the reality that a 401k is not a stagnant vault of cash. It is a living, breathing investment portfolio tied to the chaotic whims of the global economy. Furthermore, we must examine the hidden layer of taxation that destroys so many post-divorce financial plans. A 401k is funded with pre-tax dollars. The government is essentially a silent partner in that account, waiting to collect its share when the money is finally withdrawn. When a judge awards a portion of a 401k to a non-employee spouse, they are awarding a highly illiquid, tax-burdened asset. If Jessica is awarded $500,000 from Michael's account, she does not actually have $500,000 in purchasing power. If she attempts to cash that money out to buy a house or pay off debt, she will be hit with ordinary income tax on the entire withdrawal, and if she is under the age of 59 and a half, she will likely face a devastating 10% early withdrawal penalty from the Internal Revenue Service. Her settlement can instantly shrink by nearly 40%. To prevent this, the federal government mandates the use of a highly specific, notoriously complex legal order to move the funds without triggering massive tax bombs. This legal mechanism is the only shield against the IRS during a divorce involving a 401k, yet it is astonishingly misunderstood. Historical case studies reveal a landscape littered with financial ruin, simply because divorce attorneys drafted standard domestic relations orders that federal plan administrators outright rejected. A federal plan administrator operating a 401k for a massive defense contractor in Connecticut does not care what a local family court judge ordered, if the paperwork does not meet strict federal guidelines. The administrator will freeze the account, the taxes will accrue, and the spouses will be locked in a grueling war of attrition. We have established the terrifying scope of equitable distribution and the silent tax traps lurking within your pre-tax retirement accounts. We have seen how market timing can eviscerate a lifetime of savings in a matter of months while a divorce is pending. But the true danger, the ultimate point of failure in almost all of these high-asset divorces, lies in the execution of the transfer itself. A single misplaced word, a vague sentence about market gains, or a misunderstood deadline in the final paperwork can trigger an irreversible tax audit or leave hundreds of thousands of dollars stranded in a legal purgatory. The document that controls this fate is the Qualified Domestic Relations Order, and in our next segment, we are going completely under the hood to expose the fatal flaws hidden in the fine print of this federal mandate, and the devastating consequences that unfold when a federal plan administrator rejects a state judge's ruling. The Qualified Domestic Relations Order is not merely a standardized form you download from a legal portal and hand to a judge to rubber stamp on your way out of the courtroom. It is a highly specialized, ruthlessly precise federal mandate that must act as a perfect bridge between state family law and federal tax code. Under the Employee Retirement Income Security Act, commonly known as ERISA, the massive financial institutions managing corporate 401k plans are legally bound to protect the assets of the employee from all outside claims, including those of a former spouse. The only exception to this impenetrable federal shield is a perfectly drafted QDRO. When a state judge signs your divorce decree, that state order has absolutely zero power over a federal plan administrator until it is translated into a QDRO and formally approved by the financial institution. This gap between the state judgment and the federal approval is where devastating financial catastrophes occur. Let us examine a potential outcome by looking at a hypothetical case study set right now in 2026. Imagine a couple, David and Sarah, navigating a high-asset divorce in Hartford, Connecticut. David is a senior executive at a major regional insurance conglomerate, and over a 20-year career, he has built a 401k portfolio valued at $1.8 million. After months of grueling mediation, they reach a settlement. The state judge signs a final decree of divorce stating that Sarah is awarded exactly 50% of David's 401k, valued as of the date of their separation. Sarah and her general practice divorce attorney celebrate. They believe the battle is over, the assets are secured, and the financial transition is complete. They submit the state-approved order to the insurance conglomerate's plan administrator, fully expecting a check or an account transfer within a few weeks. 3 months later, Sarah receives a clinical, densely worded letter of rejection from the corporate plan administrator. The federal institution has completely denied the transfer, rendering the state judge's order utterly useless. Why does this happen? Because the state order, while legally binding for the divorce itself, failed to meet the exhaustive, hyper-specific requirements dictated by the corporation's unique summary plan description. Every single 401k plan in the United States has its own governing document, a massive rulebook that outlines exactly how and when funds can be dispersed. The plan administrator is an unyielding gatekeeper who only cares about strict compliance with that specific rulebook. In Sarah's case, her attorney made 3 fatal, highly common historical errors in drafting the order. First, the document failed to identify the exact legal name of the 401k plan. Writing David's retirement account is entirely insufficient. The document must state the precise corporate nomenclature, such as the Northeast Regional Insurance Employees Defined Contribution Plan and Trust. Second, the order failed to address market fluctuations. It awarded Sarah 50% as of a specific past date, but it completely ignored what happens to the investment gains or losses that occurred between that separation date and the day the funds are actually segregated. The plan administrator cannot and will not guess who absorbs those market shifts. Third, the order did not specify the exact method of distribution. Can Sarah take a lump sum cash payment immediately? Or does the specific corporate plan dictate that she must roll it over into an individual retirement account? Because these microscopic details were omitted or vaguely worded, the administrator slammed the door shut. This rejection plunges David and Sarah into a terrifying financial purgatory. Sarah has no access to the $900,000 she was relying on to purchase a new home and stabilize her life post-divorce. Meanwhile, David is entirely locked out of managing his own retirement account. While a QDRO is pending or under dispute, federal plan administrators typically place a complete freeze on the 401k. David cannot reallocate his investments, he cannot take a loan against his balance, and he cannot make withdrawals. They are both trapped in a frozen state while their attorneys spend thousands of dollars in additional billable hours trying to amend the QDRO, secure a new signature from a backlogged state judge, and resubmit the paperwork to the unforgiving federal gatekeeper. Now, inject the reality of market volatility into this bureaucratic nightmare. Let us say the year is experiencing a massive economic correction, a historical trend we have seen repeatedly in the New England tech and financial sectors. While Sarah and David's lawyers are spending 6 to 8 months fighting over the exact wording of the amended QDRO, the stock market takes a 15% dive. Because the original order failed to assign the risk of market loss, that $1.8 million account bleeds hundreds of thousands of dollars in value while entirely frozen. When the paperwork is finally approved, Sarah's expected payout has been decimated, and David's remaining balance is permanently damaged. The administrative delay directly caused a catastrophic destruction of wealth that could have been entirely avoided with specialized legal foresight. But there is an even darker, more terrifying risk hidden within this delay, a risk rooted deep in the historical precedents of ERISA law. What happens if David gets into a fatal car accident on Interstate 84 during those 8 months while the flawed QDRO is being disputed? Under federal law, if David dies before a valid QDRO is officially approved by the plan administrator, the state divorce decree means absolutely nothing to the financial institution. The 401k funds will automatically bypass the divorce settlement and be paid out strictly according to the beneficiary designation on file with the plan. If David forgot to update his forms, or worse, if he had quickly remarried during the administrative delay, his new spouse or an unintended beneficiary would suddenly inherit the entire $1.8 million fortune. Sarah, despite having a signed order from a state judge guaranteeing her half the money, would be left with nothing but an empty piece of paper and a massive legal bill. She would have to attempt to sue an estate or a surviving spouse in a grueling, potentially unwinnable federal lawsuit, a historical trend that has left countless former spouses entirely destitute. The mechanical precision required to draft a QDRO is not a minor administrative hurdle. It is the absolute final defense against total financial ruin. It requires attorneys who understand the intricate collision of state family law, federal tax codes, and corporate ERISA governance. But even when the document is flawlessly drafted, perfectly executed, and rapidly approved by the plan administrator, the danger is far from over. In fact, for the spouse receiving the funds, the moment that money is finally unthawed and moved out of the protective shell of the ex-spouse 401k, they are stepping directly into a labyrinth of hidden federal tax liabilities. If you make a single wrong move when deciding where to put those funds, the Internal Revenue Service will instantly claim an exorbitant percentage of your settlement. We are about to uncover the devastating reality of post-QDRO tax bombs, and exactly how an innocent transfer of wealth can trigger penalties so severe they wipe out years of legal victories. When the federal plan administrator finally approves the Qualified Domestic Relations Order, a massive psychological shift occurs. The ex-spouse receiving the funds feels an overwhelming sense of relief. The money is finally unthawed. But this exact moment of relief is historically where the most catastrophic financial mistakes are made. The Internal Revenue Service views a 401k not as a vault of your money, but as a joint venture where they hold a massive unpaid tax lien. Every single dollar inside a traditional 401k has never been taxed. It is entirely pre-tax money. When a state court judge awards a spouse $500,000 from a marital 401k, they are not awarding $500,000 in purchasing power. They are handing over a massive, ticking tax liability. The way you move that money from the corporate plan to your own control determines whether you keep your settlement or hand a massive portion of it directly back to the federal government. Let us look at a terrifyingly common scenario playing out in 2026. Imagine if we follow the story of a woman named Rebecca, navigating the aftermath of a grueling divorce in Providence, Rhode Island. Her ex-husband had a massive 401k from a local manufacturing giant, and it was aggressively divided. Rebecca was awarded $300,000 through a flawlessly executed QDRO. Rebecca is 48 years old. During the 2-year divorce process, she racked up $40,000 in high-interest credit card debt and extensive legal fees. Her immediate, completely logical instinct is to take $50,000 in cash from the QDRO settlement to wipe out her debt and secure her fresh start, and then place the remaining $250,000 into a secure, tax-deferred retirement account for her future. Her well-meaning friends or even a general practice financial advisor tells her the standard, conventional wisdom. They tell her to roll the entire $300,000 over into a personal individual retirement account to maintain its tax-deferred status, and then simply withdraw the $50,000 from her new IRA to pay her bills. This single, seemingly logical sequence of events triggers a devastating, entirely irreversible tax bomb. By moving the money into an IRA first, Rebecca unknowingly surrendered one of the most powerful hidden tax exemptions in the entire federal tax code. Under the Internal Revenue Code, specifically Section 72T, withdrawing money from a retirement account before the age of 59.5 triggers a mandatory 10% early withdrawal penalty. However, there is a historical, strictly defined exception specifically for funds distributed directly through a qualified domestic relations order. If Rebecca had requested that the corporate plan administrator cut her a check for $50,000 directly from the 401k under the QDRO, and then directly rolled over the remaining balance to her IRA, she would still owe regular income tax on the cash, but she would be entirely exempt from the 10% penalty. Because she rolled the money into her own IRA first, the QDRO shield dissolved the absolute instant the funds settled into her new account. When she subsequently withdrew the $50,000 from her IRA, the IRS treated it as a standard, unqualified early withdrawal. She is instantly hit with a $5,000 federal penalty, plus ordinary federal income tax which could strip away another 24%, plus Rhode Island state income tax. Her $50,000 withdrawal is effectively reduced to barely $30,000 in actual, usable cash. She is forced to pull even more money out of her retirement savings, triggering even more taxes, just to cover her original debts. This is a potential outcome that destroys the financial stability of newly divorced individuals every single day, completely erasing the gains they fought for in family court. Furthermore, even if Rebecca had correctly taken the cash directly from the QDRO, she would still face the brutal reality of mandatory federal withholding. The federal government does not trust you to pay your tax bill at the end of the year. If you take a direct cash distribution from a 401k QDRO, the plan administrator is legally required by federal law to automatically withhold 20% of the distribution and send it directly to the IRS. If you need exactly $50,000 to close on a new house or pay off a lawyer, you cannot simply ask for $50,000. You must calculate and ask for a significantly higher gross amount, draining your retirement settlement much faster than anticipated, just to ensure the net check clears your immediate survival needs. Now, consider the historical trend surrounding the 60-day rollover rule. Often, an individual will receive a physical check for their entire QDRO settlement, perhaps made out to them personally, with the absolute intention of depositing it into an IRA themselves. The moment that check is cut and printed by the plan administrator, a rigid 60-day federal clock begins ticking. If that money is not deposited into a qualified IRA by day 60, the entire amount becomes fully taxable as ordinary income for that current calendar year. Imagine receiving a check for $400,000, putting it in a desk drawer while dealing with the emotional chaos of packing up the marital home, and losing track of time. Missing that deadline transforms a tax-deferred retirement asset into a catastrophic, immediate tax event. You could be bumped into the absolute highest federal tax bracket, handing over 37% of your settlement to the federal government. The IRS is notoriously unforgiving regarding this deadline, and obtaining a waiver requires a lengthy, expensive, and rarely successful appeals process. We must also deeply factor in the aggressive state tax landscapes unique to New England. Massachusetts, for example, has historically implemented surtaxes on high-income earners. If a massive taxable QDRO distribution hits your tax return in a single year because of a botched rollover, it does not just trigger immense federal liabilities. It aggressively and artificially inflates your adjusted gross income for that specific year. This massive spike in paper income can potentially subject you to new layers of state taxation, phase out critical child tax credits, and drastically increase your Medicare premiums. Your hard-fought legal victory in family court instantly becomes a massive vulnerability in tax court, siphoning wealth away from your family and funneling it into state and federal treasuries. Understanding the precise mechanics of QDRO distributions, the sequence of rollovers, and the severe penalties for early withdrawal is the only way to insulate your settlement from the IRS. You must treat a 401k not as liquid cash, but as a highly volatile instrument that requires a precise, surgical extraction strategy. We have explored the devastating consequences of mishandling standard mutual fund divisions within these accounts. But what happens if the 401k you are dividing does not just hold standard mutual funds? What happens if you are divorcing an executive at a major New England corporation, and their 401k is heavily concentrated in highly appreciated company stock? The standard rules of taxation we just discussed completely fracture. There is a hidden, incredibly lucrative provision in the tax code that most divorce attorneys completely overlook, and failing to utilize it means leaving hundreds of thousands of dollars on the table. We are going to explore the obscure and highly profitable strategy of net unrealized appreciation, and how company stock can completely rewrite the rules of your divorce settlement. Net unrealized appreciation, or NUA, is one of the most powerful, least understood tax provisions in the entire Internal Revenue Code, and in the context of a high-asset divorce, failing to understand it borders on legal malpractice. To grasp the sheer magnitude of this strategy, you must first understand the fundamental difference between how the federal government taxes your labor versus how it taxes your investments. When you pull money out of a standard traditional 401k or an individual retirement account, the IRS views every single dollar of that withdrawal as ordinary income. It does not matter if that money sat in the account growing for 30 years. It is taxed at the exact same high rate as the salary you earn from your daily job. Historically, the top marginal federal income tax rate can swallow up to 37% of that money, and when you add the aggressive state income taxes characteristic of New England states like Massachusetts or Connecticut, you could be surrendering nearly half of your wealth directly to the government. Conversely, when you sell an asset that you have held for more than a year in a standard taxable brokerage account, the IRS taxes the profit at the long-term capital gains rate. This rate is historically capped around 20% for high earners. The spread between paying ordinary income tax and paying long-term capital gains tax represents an absolute fortune. New England has a deep, entrenched history of company towns and generational corporate loyalty. From the early industrial textile mills of the 19th century to the mid-20th century aerospace and defense contractors along Route 128, and now the massive pharmaceutical and biotechnology campuses sprawling across Cambridge and Boston, major employers have historically compensated their workers with company stock. For decades, corporations aggressively matched 401k contributions not with cash, but with shares of their own company. As a result, there is a historical trend in the Northeast of executives arriving at the divorce negotiation table with 401k accounts heavily concentrated in a single, highly appreciated corporate stock. This is the exact environment where the NUA strategy becomes critical. Imagine a potential outcome playing out in a Middlesex County courtroom in 2026. We will look at a couple named John and Rachel. John is a 55-year-old director at a legacy Massachusetts defense contractor. Over his 25-year career, his 401k has grown to $3 million. However, this is not a diversified portfolio of mutual funds. Because of decades of aggressive company matches and stock splits, $2 million of that account consists entirely of his employer's stock. Here is the most critical piece of data. The original price John paid for those shares, known as the cost basis, is only $400,000. The remaining $1.6 million is pure, passive market growth that occurred while the shares sat inside the 401k. That $1.6 million of pure growth is the net unrealized appreciation. When John and Rachel divorce, the judge awards Rachel exactly half of the 401k, meaning she is entitled to $1.5 million. If Rachel hires a standard family law attorney who operates on autopilot, that attorney will draft a standard qualified domestic relations order, instructing the plan administrator to roll Rachel's $1.5 million share directly into her own private individual retirement account. On paper, the transaction is clean, and the funds remain tax-deferred. But this is a catastrophic, permanent financial blunder. By rolling the highly appreciated company stock into an IRA, Rachel has permanently trapped that wealth in the ordinary income tax bracket. Whenever she decides to sell that stock and withdraw the funds in her retirement, every single dollar of that $1.5 million, and any future growth, will be taxed at the brutal maximum ordinary income tax rate. If Rachel had utilized a sophisticated financial forensics team, they would have executed the net unrealized appreciation strategy, a move that requires absolute mechanical precision in the QDRO. Instead of rolling the employer stock into an IRA, Rachel's QDRO would demand that her share of the defense contractor's stock be distributed entirely in kind directly into a standard taxable brokerage account. In kind is a legal term meaning the actual physical shares are transferred, not the cash equivalent. When this highly specific maneuver is executed, the IRS rules completely change. At the exact moment of the transfer, Rachel is only required to pay ordinary income tax on her portion of the original cost basis. Since her half of the cost basis is only $200,000, she pays ordinary income tax on that relatively small fraction today. The remaining $800,000 of growth, her portion of the net unrealized appreciation, transfers over completely tax-free at that moment. The magic of this strategy reveals itself when Rachel eventually decides to sell those shares in her new brokerage account. When she clicks sell, that entire $800,000 of historical growth is taxed exclusively at the long-term capital gains rate. By intentionally triggering a small manageable tax bill on the cost basis today, Rachel successfully rescues hundreds of thousands of dollars from the highest tax brackets tomorrow. Historical case studies of high net worth divorces in the Boston area demonstrate that properly executing an NUA distribution can literally save an ex-spouse upwards of $250,000 in lifetime federal and state tax liabilities, preserving the true purchasing power of the settlement. However, the trapdoors hidden within this strategy are devastating. The most common point of failure occurs in the exact wording of the QDRO. If the divorce attorney includes a single sentence instructing the federal plan administrator to equalize the account, or if they fail to explicitly mandate an in-kind distribution, the corporate plan administrator will look at the order and simply hit the liquidate button. They will sell the company stock inside the 401k, generate $1.5 million in cash, and transfer that cash to Rachel. The absolute second those shares are liquidated inside the 401k wrapper, the net unrealized appreciation is permanently destroyed. The IRS code strictly dictates that NUA only applies to actual shares of employer stock. You cannot reverse a liquidation. Once the administrator sells the stock, Rachel is handed a massive pile of cash that is forever doomed to be taxed as ordinary income, completely obliterating the potential for capital gains treatment. Furthermore, the timing is notoriously unforgiving. To qualify for NUA, the entire balance of the plan must be distributed within a single tax year. If Rachel leaves even $1 of her awarded share behind in the original 401k, the entire strategy is invalidated by the IRS, triggering an audit and massive penalties. We have just dissected how a 401k is forensically dismantled, how hidden tax bombs erase wealth, and how obscure IRS provisions like NUA can be weaponized to save fortunes. But everything we have discussed so far involves money that actually exists in an account today. It involves assets that have a present, definable value. In the upper echelons of New England corporate wealth, the vast majority of an executive's net worth is not sitting in a 401k. It is locked in a shadow economy of phantom equity, unvested stock options, and golden handcuffs. These are assets that do not mathematically exist yet, but hold the promise of millions of dollars in the future. How does a judge divide a ghost? How do you split a fortune that a company can legally revoke at any moment? We are about to enter the most aggressive, legally complex battlefield in modern divorce, a realm where executives intentionally manipulate their own compensation to starve out their spouses. The shift from traditional retirement accounts to complex executive compensation packages has fundamentally altered the landscape of high net worth divorces in the Northeast. Historically, wealth was accumulated in predictable, linear vehicles like pensions or standard 401k plans. Today, if you look at the corporate ecosystems dominating New England, particularly the biotechnology hubs in Kendall Square, or the massive financial institutions in Fairfield County, base salaries are merely the tip of the iceberg. The true wealth of a corporate executive is heavily concentrated in restricted stock units, commonly known as RSUs, non-qualified stock options, and deferred compensation plans. These instruments are colloquially referred to as golden handcuffs because they are entirely contingent on the executive remaining with the company for a specified period, known as a vesting schedule. Until those shares vest, they are effectively ghost assets. They hold massive theoretical value, but they cannot be sold, they cannot be transferred, and they technically do not even belong to the employee yet. This creates an unprecedented forensic challenge in family court. How do you equitably divide a multi-million-dollar asset that is legally nothing more than a corporate promise contingent on future events? To understand the potential outcomes, imagine a scenario unfolding right now in 2026. Let us examine a case study involving a couple named Mark and Elena. Mark is a chief medical officer at a prominent Boston pharmaceutical company. His base salary is $300,000, but his compensation package includes $4 million in unvested restricted stock units. These RSUs are scheduled to vest over the next 4 years, heavily tied to the successful FDA approval of a new drug portfolio. After 15 years of marriage, Elena files for divorce. If Mark simply had $4 million in a traditional 401k, the division, while complex, follows the mechanical QDRO processes we have already established. But because these are unvested RSUs, Mark possesses a terrifying degree of leverage. Historical trends in executive divorces show that the employee spouse will immediately argue that these unvested shares are completely separate property. Mark will claim that the RSUs were granted strictly as an incentive for his future performance and future retention, both of which will occur entirely after the marriage has ended. Therefore, he will argue Elena is entitled to absolutely none of it. Elena, on the other hand, will argue that the RSU grant was a reward for his past performance, a track record built during their marital partnership, and therefore she deserves 50% of the total grant. When this collision of perspectives reaches a New England judge, the court must dissect the exact wording of the original corporate grant documents to determine the true intent of the compensation. Was it a reward for the past, or an incentive for the future? To solve this, Massachusetts courts, establishing precedents that ripple across neighboring states, utilize a sophisticated mathematical formula known as a time rule fraction. The court will calculate the exact number of months Mark and Elena were married during the specific vesting period of the stock, and divide that by the total number of months in the entire vesting period. This fraction determines the precise percentage of the unvested shares that belong to the marital estate. However, establishing the mathematical formula is only the beginning of the nightmare. Even if a judge rules that Elena is mathematically entitled to $1 million of those unvested RSUs, she faces a massive structural barrier. Unlike a 401k, you cannot execute a qualified domestic relations order against unvested corporate stock. The vast majority of corporate plan documents strictly prohibit the transfer or assignment of unvested equity to anyone, including a former spouse. The federal plan administrator will flatly refuse to create a separate account for Elena. To bypass this corporate firewall, legal practitioners must implement a highly volatile mechanism known as a constructive trust. Under a constructive trust, the state court orders Mark to hold Elena's share of the RSUs in his own name. He essentially becomes a forced fiduciary for his ex-wife. As the years pass and the shares finally vest, Mark is legally obligated to immediately exercise or sell Elena's portion, calculate the resulting taxes, and transfer the net cash proceeds to her. This arrangement creates an explosive dynamic. The ex-spouses remain financially entangled for years after the divorce decree is signed. Furthermore, the tax implications of a constructive trust are brutally inefficient and frequently lead to intense litigation. Because the RSUs are technically in Mark's name, the IRS views the vesting event entirely as Mark's ordinary W-2 income. The company will automatically withhold a massive percentage of the newly vested shares to cover federal and state taxes at Mark's specific executive tax bracket, which in 2026 could easily exceed 45%. When Mark transfers the remaining cash to Elena, she is receiving a heavily depleted asset. Forensic accountants must be hired to calculate exactly how much tax Mark actually owed versus what was automatically withheld, frequently discovering that the executive spouse is using the ex-spouse's equity to subsidize their own personal tax liabilities. But the most aggressive manipulation tactics occur behind closed corporate doors before the divorce is even finalized. Historical case studies reveal executives intentionally negotiating with their board of directors to restructure their compensation packages the moment they realize a divorce is imminent. An executive might voluntarily reduce their own base salary and request that all future compensation be heavily weighted in entirely new performance-based stock options granted after the date of separation. By artificially suppressing their present income and pushing all wealth generation into post-marital phantom equity, they effectively starve the marital estate of liquid assets. Moreover, what happens if the executive intentionally decides to manipulate the vesting timeline itself? Imagine Mark realizes that in exactly 6 months, $2 million of his RSUs are scheduled to vest, and under the constructive trust, he will be forced to hand half of that fortune over to Elena. What prevents Mark from abruptly quitting his job at the pharmaceutical company and taking a lucrative position at a competing biotech firm? If he resigns before the vesting date, the unvested RSUs are entirely forfeited. They vanish into thin air. Elena's $1 million settlement is instantly reduced to zero. Mark, however, likely negotiated a massive sign-on bonus or a shadow equity grant at his new company to make up for the forfeited shares, a new asset entirely shielded from the divorce decree. The constructive trust is a fragile bridge built over a chasm of corporate loopholes. It relies entirely on the continued employment and good faith of an individual who may have every personal and financial incentive to see those assets destroyed. We have seen how executives can manipulate their employment status to evaporate unvested wealth, but this destructive capability extends far beyond simply quitting a job. There is a deeply insidious corporate maneuver utilized by vindictive spouses to purposely tank their own company's valuation, utilizing the very mechanisms of corporate governance to burn the marital estate to the ground. We are about to examine the devastating reality of minority shareholder oppression in closely held family businesses, and how a spouse can legally bankrupt a company just to ensure their ex-partner walks away with absolutely nothing. The transition from corporate boardrooms to family-owned enterprises introduces an entirely different level of financial warfare. In New England, multi-generational privately held businesses, ranging from precision manufacturing plants in Worcester to massive lumber and paper operations in Maine, are the lifeblood of regional wealth. Unlike public stock, which has a clear daily ticker price, the value of a private company is highly subjective and easily manipulated by whoever holds the operational reins. Let us examine a terrifying case study set in 2026. Imagine James and Emily, a couple navigating a high-conflict divorce in New Hampshire. James is the president and 60% majority shareholder of a highly lucrative, privately held logistics company. During the marriage, for purely strategic estate planning and tax distribution purposes, James transferred the remaining 40% of the corporate shares into Emily's name. They are both owners on paper, but James completely controls the daily operations, the corporate bank accounts, and the board of directors. In a standard publicly traded company, if Emily wants out, she simply logs into a brokerage account and sells her shares on the open market. But in a closely held family business, there is no open market. Her 40% ownership is entirely illiquid. It is a piece of paper that holds theoretical value, but cannot be easily converted into cash unless James agrees to buy her out, or the entire company is sold. This lack of liquidity grants James the power to execute a brutal, legally permissible strategy known as minority shareholder oppression, or a corporate freeze-out. His ultimate goal is to completely financially starve Emily, so she is forced to sell her shares back to him for pennies on the dollar just to survive the divorce proceedings. The mechanics of this freeze-out are shockingly simple and historically devastating. Step 1 involves cutting off the immediate cash flow. James, utilizing his power as majority shareholder, immediately terminates Emily from any salaried administrative position she may have held on paper, severing her regular W-2 income and terminating her corporate health insurance. Step 2 is the termination of corporate distributions. While they were happily married, James regularly authorized massive quarterly dividend payouts to the shareholders, flooding their joint bank accounts with cash. Now that they are divorcing, James suddenly declares that the company is facing an unpredictable economic environment and must retain all earnings for future corporate growth. He legally votes to halt all dividend distributions. Emily's 40% stake suddenly yields absolutely zero cash flow. But step 3 is where the strategy turns into a devastating financial weapon. Many privately held businesses in New England are structured as S-corporations or limited liability companies. Under federal tax law, these are pass-through entities. This means the corporation itself does not pay federal income tax. Instead, the company's profits pass directly through to the personal tax returns of the owners, proportionate to their ownership percentage. Imagine the logistics company generates $3 million in pure profit in 2026. Because Emily owns 40% of the shares, the Internal Revenue Service dictates that $1.2 million of that profit must be reported on her personal individual tax return. She is legally responsible for paying the federal and state income taxes on that $1.2 million. However, because James halted all cash distributions in Step 2, Emily does not actually receive a single dollar of that profit in her bank account. She is hit with a phantom income tax bomb. She might owe $400,000 to the IRS and state tax boards for money she never actually touched. This potential outcome forces minority spouses into severe personal debt or bankruptcy, giving the majority shareholder incredible leverage to acquire their shares for a fraction of their true historical value. While Emily is drowning in phantom tax liabilities, James is actively working to permanently lower the paper valuation of the business. If the court eventually forces James to buy Emily out, he wants the business to look as unprofitable as legally possible. Forensic accountants analyzing New England family court records frequently uncover massive, sudden spikes in executive compensation just prior to a divorce filing. James might artificially double his own salary, reclassifying company profits as personal operational expenses. He might suddenly decide the company needs to purchase an entirely new fleet of delivery trucks, rapidly accelerating the depreciation of those assets to show massive paper losses on the corporate balance sheet. He might prepay years of commercial rent or deliberately slow down the collection of outstanding accounts receivable. To a judge, these actions can easily be disguised as conservative, aggressive business management, completely obscuring the malicious intent to diminish the marital estate. Even if Emily's legal team successfully hires top-tier forensic accountants to reverse engineer these financial manipulations and establish a fair, multi-million-dollar valuation for the business, they inevitably crash into another highly complex legal paradox, known as double dipping. This is a massive area of contention in equitable distribution states. Let us assume the judge values the business at $10 million and orders James to pay Emily $5 million for her half. The valuation of that business was heavily based on its ability to generate future income. However, Emily also requests monthly alimony to maintain her standard of living. The court calculates James's ability to pay that alimony based on the exact same income stream generated by the logistics company. James's attorneys will fiercely argue that this is fundamentally unjust. They will argue that the court is forcing James to pay Emily for the capital value of the business, and then forcing him to pay her again from the income that identical asset generates. It is the equivalent of forcing someone to give you half the apples an orchard will ever produce, and then also forcing them to give you half the physical orchard itself. Navigating the historical precedents of double dipping requires an absolute mastery of both corporate valuation methodology and family law statutes, as courts have wildly differing interpretations on how to separate an individual's personal earning capacity from the intrinsic value of the enterprise they operate. The battlefield of the closely held family business is fraught with tax traps, forensic accounting warfare, and corporate manipulation. But whether a couple is fighting over a manufacturing plant, an executive 401k, or restricted stock units, the wealth generated inevitably flows into the physical landscape. It flows into the multi-million-dollar primary residences, the sprawling vacation compounds on Cape Cod, and the lucrative commercial real estate portfolios dotting the New England coastline. Real estate is traditionally viewed as the safest, most secure asset class in the American economy. Yet, in the context of a high-asset divorce, the family home is not a sanctuary. It is frequently a ticking financial time bomb, loaded with hidden capital gains liabilities and toxic mortgage structures. We are about to strip the emotional attachment away from the marital home and expose the brutal mathematical reality of why fighting to keep the house is often the most catastrophic financial mistake a divorcing spouse can possibly make. Before we begin, a quick and important disclaimer. The information presented in this video is strictly for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Divorce and the division of retirement assets, such as 401k plans, involve highly complex federal and state laws that are subject to change and vary significantly depending on your specific jurisdiction. We are exploring historical trends and case studies, not providing personalized counsel. Always consult with a licensed attorney, a certified financial planner, or a qualified tax professional before making any decisions regarding your assets, marriage, or legal standing. You must conduct your own due diligence, as relying solely on educational content for legal strategies can result in severe financial consequences. The emotional gravity of a primary residence cannot be overstated. When a marriage collapses, the human instinct is to cling to whatever represents stability, safety, and continuity, especially when children are involved. In New England, where property is deeply tied to historical legacy, specific school districts, and community standing, the marital home frequently becomes the ultimate prize in family court. However, treating a piece of physical real estate as an equal counterweight to a liquid retirement account is a devastating mathematical illusion. On a balance sheet, $1 million in home equity might look exactly like $1 million in a 401k. But the moment you finalize the divorce, the true nature of these assets diverges radically, often leaving the spouse who kept the house completely financially paralyzed. To illustrate this potential outcome, imagine a scenario taking place right now in the year 2026. Let us look at a couple named Thomas and Olivia, living in a classic colonial home in Fairfield County, Connecticut. Through the course of their 20-year marriage, they have accumulated two primary assets. They have Thomas's corporate 401k, which has a current balance of exactly $800,000. They also own their marital home, which has a current market appraisal of $1.2 million, with a remaining mortgage of $400,000. This means there is exactly $800,000 of pure equity trapped inside the physical structure of the house. During the mediation process, Olivia fights aggressively to keep the house so their teenage children can remain in their current high school district. To achieve this, she agrees to a seemingly perfectly balanced settlement. Olivia will waive her right to a qualified domestic relations order and let Thomas keep the entirety of his $800,401,000. In exchange, Thomas will deed the house entirely to Olivia, leaving her with the $800,000 in home equity. They shake hands, the judge signs the decree, and Olivia believes she has secured her family's future. The reality is that Olivia has just walked into a catastrophic financial trap. The first point of failure is the mortgage itself. When Thomas deeds his half of the property to Olivia, his name does not magically disappear from the original loan document. The bank does not care about their divorce decree. To remove Thomas from the financial liability, as the court order undoubtedly requires, Olivia must completely refinance the $400,000 mortgage solely in her own name. This brings us to the brutal historical trends of interest rates and individual qualification. When Thomas and Olivia bought the house a decade ago, they secured a highly favorable interest rate based on their combined dual income. Now in 2026, Olivia must qualify for a new loan based entirely on her single income, and she must do it at current market rates, which may be drastically higher. If her alimony and individual salary do not meet the bank's strict debt-to-income ratio requirements, her refinancing application will be flatly denied. She will be in direct violation of her own divorce decree, forcing a chaotic emergency liquidation of the property. Even if Olivia successfully refinances the mortgage, the hidden carrying costs of New England real estate immediately begin eroding her wealth.
A 401k is a passive asset.
It sits in a server, generating compound interest and requiring zero daily maintenance. A classic New England colonial home is an active, depreciating liability that constantly demands cash. Olivia is now solely responsible for the massive property tax burdens characteristic of Connecticut and Massachusetts. She alone must pay the exorbitant winter heating bills, often relying on expensive oil furnaces common in older northeastern homes. When the slate roof leaks or the ancient plumbing fails, there is no joint bank account to draw from. Every single repair drains her post-tax, liquid cash reserves. She becomes fundamentally house poor, living inside a multi-million-dollar asset while simultaneously struggling to afford basic utilities and groceries. But the absolute most destructive element of this settlement lies hidden deep within the federal tax code, specifically Section 121 regarding the capital gains exclusion on a primary residence. When a married couple sells a primary home, the Internal Revenue Service allows them to exclude up to $500,000 of profit from capital gains taxes. However, when a single, divorced individual sells that exact same home, the exclusion drops by exactly half to $250,000. Let us trace the mathematical timeline. Imagine Thomas and Olivia originally purchased the Fairfield County home for $400,000. By 2026, it is worth $1.2 million. There is $800,000 of historical appreciation built into the walls of that house. If they had sold the house together during the divorce and split the cash, their married $500,000 exclusion would have shielded the vast majority of that profit from the federal government. But Olivia chose to keep the house to preserve the illusion of normalcy. 5 years later, the children graduate high school, the maintenance costs become too overwhelming, and Olivia is finally forced to sell the property. Because she is now a single owner, she can only shield $250,000 of the profit. The remaining $500,000+ of historical appreciation, is suddenly subject to massive federal and state long-term capital gains taxes. She is forced to pay taxes on the massive growth that occurred while she was still married to Thomas. Thomas, meanwhile, has been watching his $800,000–$401,000 compound completely tax-deferred, entirely insulated from property taxes, leaky roofs, and the immediate demands of the IRS. Olivia absorbs the entirety of the marital tax burden simply because she chose physical bricks over liquid equities. This scenario highlights the ultimate danger of comparing pre-tax retirement accounts to highly illiquid physical real estate. Forensic accountants refer to this as the tax-affected value of an asset. You can never look at the top-line number on an appraisal or a brokerage statement. You must calculate exactly what that asset will be worth after the government extracts its mandatory toll. The spouse who takes the liquid investments almost always walks away with a drastically superior financial outcome, while the spouse who fights for the emotional comfort of the home often ends up selling it under duress, losing hundreds of thousands of dollars to taxation and closing costs. We have mapped the devastating pitfalls of dividing the marital home and the psychological traps of equitable distribution. We have seen how visible assets, whether they are brick-and-mortar houses or corporate stock options, can be weaponized against an unsuspecting partner. But what happens when the wealth is not visible at all? What happens when a sophisticated, high-net-worth individual spends years preparing for a divorce by systematically moving millions of dollars into complex offshore structures, anonymous shell companies, and untraceable digital ledgers? The New England court system operates on the assumption of full financial disclosure, but we are about to plunge into the shadowy underworld of asset dissipation and forensic tracking, where proving what you own becomes an international legal war. The legal foundation of any divorce proceeding in the United States, including the historically rigorous jurisdictions of New England, is the absolute mandate of mandatory financial disclosure. When you file for divorce, you are required under penalty of perjury to submit a comprehensive, sworn financial statement detailing every single asset, liability, income source, and expense to your name. The entire system of equitable distribution relies on the honor system of this initial disclosure. But in the realm of high-net-worth divorces, where decades of accumulated wealth and complex executive compensation packages are on the line, the honor system frequently disintegrates. We enter the fiercely contested arena of asset dissipation, a sophisticated, premeditated strategy where one spouse intentionally conceals, transfers, or destroys marital wealth to prevent the other spouse from receiving their equitable share. This is not about hiding physical cash under a mattress. In the modern financial ecosystem of 2026, hiding money is a highly digitized, strategically layered enterprise that requires elite forensic accountants to untangle. To understand the mechanics of this financial warfare, imagine a scenario unfolding in the Massachusetts court system today involving a couple named Arthur and Eleanor. Arthur is the managing partner of a highly lucrative commercial real estate development firm in Boston. Anticipating that his marriage to Eleanor is heading toward an inevitable collapse, Arthur spends 2 years quietly orchestrating a massive reduction of their visible marital estate. If Arthur simply transferred $2 million from their joint checking account into a secret offshore bank account in the Cayman Islands, it would be instantly detected by the most basic subpoena of his primary bank records. Instead, Arthur employs a strategy of manufactured distress and phantom liabilities. He utilizes the complex corporate structure of his real estate firm to create an illusion of impending financial ruin. Arthur travels to Wyoming, a state historically renowned for its aggressive corporate anonymity laws, and establishes an opaque limited liability company. Because Wyoming does not require the public disclosure of the underlying beneficial owners of an LLC, Arthur's name never appears on any public registry. He uses a registered agent to file the paperwork, creating a completely untraceable corporate entity. Arthur then drafts highly technical, legally binding promissory notes, effectively manufacturing a scenario where his Boston real estate firm borrows $3 million from this mysterious Wyoming LLC. He begins systematically draining the cash reserves of his Boston business, wiring massive monthly interest payments to the Wyoming Shell Company to service this fabricated debt. When Eleanor finally files for divorce in 2026, Arthur presents his sworn financial statement to the judge. On paper, his business appears to be suffocating under millions of dollars of high-interest corporate debt, drastically reducing the overall valuation of his company and severely limiting the pool of marital assets available for Eleanor to claim. Uncovering this deception requires an excruciatingly expensive and time-consuming forensic counterattack. Eleanor cannot rely on a standard family law attorney. She must hire a forensic certified public accountant. This forensic expert must meticulously comb through thousands of pages of corporate general ledgers, tax returns, and bank statements. The forensic accountant is looking for anomalies, specifically the sudden appearance of a massive new creditor just prior to the breakdown of the marriage. They must then petition the family court judge for the authority to issue sweeping subpoenas across state lines, forcing the registered agent in Wyoming to reveal the true beneficial owner of the shell company. This process can take months of brutal legal wrangling, while Arthur's attorneys file endless motions to quash the subpoenas, claiming they are irrelevant fishing expeditions designed to harass his business operations. The strategy Arthur is deploying is an economic war of attrition. He is intentionally building a financial labyrinth so dense and so incredibly expensive to navigate that he hopes Eleanor will simply run out of legal funding and be forced to accept a heavily discounted settlement just to stop the bleeding of attorney fees. While international shell companies represent the traditional method of asset concealment, the modern frontier of financial deception lies in the blockchain. Historical trends over the last decade have shown a massive surge in spouses attempting to hide wealth through digital assets. Imagine another 2026 case study involving a Cambridge technology executive named Marcus and his wife Diana. Marcus has a massive traditional 401k and a visible brokerage account, but for the past 5 years, he has been systematically siphoning a portion of his annual executive bonuses into cryptocurrency. The inherent nature of cryptocurrency is exactly what makes it so attractive for asset concealment. While the blockchain ledger itself is completely public and transparent, the identities attached to the digital wallets are entirely anonymous. Marcus purchases his digital assets through a centralized exchange, but then immediately transfers them to a cold storage hardware wallet, a physical device no larger than a standard USB drive. He places this drive in a safe deposit box and entirely omits the existence of this $2 million digital fortune from his mandatory financial disclosures. If Diana is unaware that Marcus ever purchased cryptocurrency, that wealth effectively ceases to exist in the eyes of the family court. However, if Diana or her attorneys suspect hidden digital assets, the forensic tracing process begins at the fiat on-ramp. In the United States, centralized cryptocurrency exchanges are heavily regulated financial institutions subject to strict Know Your Customer and anti-money laundering laws. Diana's forensic team will subpoena the family's traditional bank accounts, searching for historical wire transfers or automated clearinghouse deposits directed to known cryptocurrency exchanges. Once they identify the exchange, they subpoena the exchange itself to acquire Marcus's complete transaction history. The forensic team then utilizes sophisticated blockchain analytics software to trace the exact movement of the funds from the exchange to the anonymous cold storage wallet. The legal climax of this scenario is often a standoff of intentional spoliation. When confronted with the irrefutable blockchain evidence that he transferred $2 million to a cold wallet, Marcus might attempt the ultimate digital defense. He might stand before the judge and claim that he tragically lost the physical hardware wallet, or that he forgot the complex cryptographic seed phrase required to access the funds, rendering the money permanently lost in cyberspace. In the early days of cryptocurrency, courts struggled with how to handle these claims. However, current historical trends in New England jurisprudence show judges taking an incredibly aggressive stance against this tactic. If the court determines that Marcus is lying or intentionally destroyed access to the marital property, the judge will employ a devastating legal doctrine known as an adverse inference. The judge will legally assume that Marcus still has full access to the $2 million and will mathematically attribute that entire sum to his side of the marital ledger, forcing him to surrender his rights to the visible, liquid assets like the marital home and the traditional 401k to balance the scales for Diana. The pursuit of hidden assets is a high-stakes gamble that tests the limits of the civil justice system. It pits the investigative power of forensic accounting against the deceptive architecture of shell companies, phantom debts, and decentralized finance. It requires victims of financial abuse to wager their remaining liquid wealth on the hope that their experts can find the smoking gun before the legal retainers run dry. But what happens when the forensic reports are finally complete? The hidden assets are undeniably exposed, and the absolute truth of the financial deception is laid bare before a New England family court judge. You might logically assume that the deceptive spouse faces immediate criminal prosecution, or that the innocent spouse is automatically awarded the entirety of the uncovered wealth as a punitive measure. The historical reality of equitable distribution is far more complex, and the final judgment often contains one last, devastating structural twist that completely reshapes the future of both parties involved. When the gavel finally falls and the family court judge issues the final decree of divorce, the spouse who successfully exposed the hidden assets often experiences a profound, entirely misplaced sense of total victory. The forensic accountants have done their job, the offshore shell companies have been dragged into the light, and the decentralized cryptocurrency wallets have been mathematically attributed to the deceptive partner. To balance the scales, the judge implements a disproportionate division of the visible marital estate. The innocent spouse is awarded the entirety of the massive corporate 401k, the primary residence, and a significant equalization payment to compensate for the wealth the deceptive spouse attempted to steal. It looks like a flawless legal triumph on paper. However, the historical reality of equitable distribution contains a brutal, often catastrophic structural twist regarding federal tax liability, a twist that frequently turns a multi-million-dollar settlement into a devastating financial prison. To understand this potential outcome, we must examine the terrifying legal concept of joint and several liability. Throughout the marriage, the couple likely filed joint federal and state tax returns. By signing that joint return, both individuals told the federal government that they take full 100% personal responsibility for the accuracy of every single number on those documents. The Internal Revenue Service does not care about your marital dynamics. They do not care who was the primary breadwinner, and they certainly do not care who was secretly funneling money into anonymous Wyoming limited liability companies. Imagine a case study unfolding in 2026 involving a couple named Richard and Patricia, navigating the aftermath of a grueling divorce in Portland, Maine. Patricia spent 2 years and hundreds of thousands of dollars in legal fees exposing Richard's elaborate network of hidden commercial real estate investments. The judge, furious at Richard's blatant asset dissipation, awarded Patricia the entire $1.5 million marital 401k via a qualified domestic relations order. Patricia rolls the funds into her own individual retirement account, believing she is finally secure. 2 years later, the ultimate trap is sprung. The IRS flags the historical joint tax returns filed during the final years of the marriage. The forensic audit that Patricia utilized in state family court practically handed the federal government a roadmap of Richard's unreported income. The IRS officially determines that because Richard hid millions of dollars in offshore accounts, the couple owes $400,000 in back taxes, severe fraud penalties, and compounding interest. Richard, anticipating this exact scenario, has strategically structured his remaining post-divorce life to be entirely judgment-proof. He has moved his assets into irrevocable trusts, or perhaps relocated to a jurisdiction that severely limits aggressive debt collection. The IRS, a federal agency armed with the most powerful collection tools on earth, does not waste time chasing ghosts. They look for the path of least resistance. They look for massive, highly visible, easily accessible pools of liquid capital. They look directly at Patricia's newly funded $1.5 million IRA. Patricia's attorneys immediately point to the state divorce decree. That decree almost certainly contains a standard tax indemnification clause, a legal paragraph explicitly stating that Richard is solely responsible for any historical tax liabilities resulting from his undisclosed business dealings. But here is the devastating historical trend that shatters thousands of post-divorce financial plans. The Internal Revenue Service is not bound by a state court family law decree. The IRS views that indemnification clause as a private civil contract between Patricia and Richard. It holds absolutely zero weight against federal tax law. The federal government will bypass the state order entirely, place a massive federal tax lien on Patricia's retirement accounts, and legally seize the $400,000 directly from her settlement. The IRS will coldly instruct Patricia that if she wants her money back, she must hire a new attorney and sue Richard in state court for breaching the indemnification clause, triggering yet another multi-year, incredibly expensive legal war of attrition. Patricia's only federal defense is a highly complex, statistically improbable mechanism known as innocent spouse relief. To secure this relief, Patricia must prove to the IRS that she had absolutely no knowledge, and no reason to know, that the tax returns she signed were fraudulent. But the very evidence she used to win her divorce settlement is now weaponized against her. The IRS will review the family court transcripts and point out that the couple's lavish lifestyle, the multi-million-dollar home in Maine, and the luxury vehicles were mathematically impossible to support on the income reported on their tax returns. The federal government will argue that Patricia willfully ignored the financial discrepancies and enjoyed the fruits of the unreported income. Historical case studies demonstrate that proving absolute ignorance to the IRS after living a high net worth lifestyle is one of the most difficult, grueling administrative battles in American tax law, and failure means Patricia absorbs the entirety of her ex-husband's financial crimes. Beyond the lurking threat of federal tax audits, there is another devastating structural timeline that dictates the future of divorcing couples in New England, and it involves the absolute rigidity of federal entitlement programs. A 401k is designed to work in tandem with Social Security benefits. For spouses who sacrifice their own career trajectories to raise children or support a high-earning executive, their post-divorce survival relies heavily on derivative Social Security benefits. Under federal law, a divorced spouse is entitled to collect benefits based on their ex-partner's lifetime earnings record, provided the marriage lasted for exactly 10 consecutive years. This 10-year rule is not a suggestion. It is a rigid, unforgiving mathematical cliff. In the high-stakes legal arenas of Massachusetts and Connecticut, we observe a ruthless historical trend of strategic divorce filings timed specifically to destroy this federal benefit. Imagine a high-earning tech executive who realizes the marriage is failing. If they intentionally file for divorce and push for a rapid settlement so that the final decree is signed at 9 years and 11 months, the dependent spouse permanently loses all rights to the high earner's Social Security record. That single missing month can equate to hundreds of thousands of dollars in lost retirement income over the course of a 20-year life expectancy. Savvy family law practitioners must forcefully drag out the discovery process, utilizing every legal delay tactic available, simply to push the final judgment date past that critical 10-year threshold, ensuring the dependent spouse secures a baseline of federal survival income to supplement their fractured 401k. The history of 401k divorce in New England is a stark, unforgiving masterclass in the realities of wealth transfer. We have traced the evolution from archaic common law to the sheer mechanical complexity of the Qualified Domestic Relations Order. We have exposed the invisible tax bombs waiting inside your pre-tax accounts, the catastrophic risks of trading liquid equities for the emotional comfort of the marital home, and the intense forensic warfare required to untangle corporate phantom equity. A divorce decree is not the end of the conflict. It is merely the opening of a new, highly volatile chapter of asset defense. Securing a court order that says you are owed $1 million means absolutely nothing if you do not understand the hyper-specific federal, state, and corporate laws required to actually collect, transfer, and insulate that money from taxation and hostile legal maneuvers. But what happens when the state family court system fails to enforce its own rulings entirely? What happens when you spend years securing a massive equitable distribution payout, only to watch your ex-spouse intentionally walk into a federal courthouse the very next day, and use the complex shield of federal bankruptcy to legally erase the equalization payments they owe you, turning your hard-fought judgment into a worthless piece of paper? In our next deep dive masterclass, we are crossing the jurisdictional lines and taking you inside the brutal, highly technical world of family law bankruptcy collisions, exposing exactly how wealthy individuals manipulate Chapter 13 restructuring to legally default on their divorce settlements, and the critical maneuvers you must execute to ensure your assets survive the ultimate financial disappearing act.